tenants and landlords kind of mitigate the moratorium. So when we're talking about fair housing, we're talking about a dwelling. And this definition is really important because it determines whether or not a building or something that an owner possesses falls under fair housing guidelines. So when we're talking about a dwelling, we're talking about any building, structure, or portion thereof, which is occupied as or designed or intended for occupancy as a residence by one or more families, and any vacant land which is offered for sale or lease for the construction or location thereon of any such building, structure, or portion thereof. And so what's really important here is that it could be a building, it could also be vacant land. When you think about mobile homes and things like that, those also fall under fair housing laws. In addition to dwellings, we want to think about transactions. So different types of transactions are things like to rent. So that includes leasing and subleasing, otherwise granting for consideration the right to occupy the premise not owned by the occupant, and then to otherwise make unavailable or deny a dwelling. And so that could be done a number of ways. When we're talking about rental, sales, lending, appraisals, you can see on the list there are a number of transactions that would trigger fair housing laws. Something that people often overlook is that maintenance also falls into that category of transactions that would trigger fair housing laws. So when you're talking about people who are liable, your maintenance staff is equally liable for upholding fair housing laws. And that's especially important when we talk about reasonable accommodations and modifications, which we'll get into in a bit. In terms of what would be a violation of these laws, it would be things like differential treatment or disparate impact or retaliation. Differential treatment is the act of limiting access to housing or facilities or offering negative terms or conditions. Disparate impact is the unintended negative consequence that occurs as a result of a policy or procedure. Retaliation, that's basically punishing someone for trying to exercise their rights or helping someone else to exercise their rights. So things to remember as we go through talking about the protected classes are that policies, rules, and screenings cannot negatively impact the protected class. Damage is damage, and we're really trying to address behaviors and not stereotypes. So what are the protected classes? At the federal level, there are 7: race, color, national origin, sex, familial status, religion, and disability. At the state level, there are additional protections, and then depending on the municipality, there are even more protections. The ones in bold are the ones that we'll be covering today. Race, I think that's self-explanatory. Color, there is colorism, and so the color of someone's skin is a protected class. Okay, so the first one, national origin. We're talking about individuals who are or whose ancestors are from a country other than the United States, including Native Americans. When we're thinking about national origin, we want to make sure that our policies aren't targeting individuals due to their protected class status and their national origin. So documentation is a big one when we're thinking about that. Also, there's often confusion around what's required. So you can't refuse service due to limited English proficiency. At the same time, you're also not required to provide materials in other languages. And so what that means is that if someone comes into your office and they're trying to access housing and they don't speak English, you cannot deny them for the simple fact that they don't speak English. What you would do in that case is say, I'm happy to serve you if you come back with a translator or an interpreter. So you're still able to provide that service, and you're saying that you will provide whatever is needed for them to be able to go through the process of trying to acquire housing. But they are responsible for providing the resource that's going to allow them to access that service. And then when it comes to providing materials in other languages, HUD guidance says that you are not required to provide materials in other languages. However, if you feel that that's something that you want to do and you're unsure about how to do that, then you can contact our agency and we can help you with that. Okay, when we're talking about sex, we're talking about biological, gender identity, sexual orientation, domestic violence survivor status, as well as sexual harassment. So we're not just talking about biological. Gender identity, this is particularly important when you get into shelters and things like that. Um, we have a separate presentation that our agency offers that goes a little more in depth into that. But basically, the point here is to understand that things like gender identity, sexual orientation, and domestic violence survivor status, those all fall under the sex protection. And so real quick, domestic violence survivor status, again, you could have a policy that has a disparate impact on domestic violence survivors. So looking at your noise ordinance, for example, or complaints to the police. If you have a policy where, a certain number of police visits is an automatic eviction, that could have a disparate impact on domestic violence survivors. And again, if you have questions about any of these things, type them in the chat and we'll address them at the end. Otherwise, you can feel free to send our organization an email and we will certainly get back to you. All right, so familial status. When we're talking about familial status, we're talking about any household containing one or more persons under the age of 18. And so that includes parents who, have biological or legal custody, the designees of a parent, people who are pregnant, and then people who are in the process of securing legal custody. And so when we're talking about familial status and you're thinking about your policies and procedures, or as you're trying to obtain housing yourself, you want to look for red flags, including rules that target rules that specifically are targeted towards people who are under the age of 18. So maybe there's a policy that certain amenities are not accessible to people under the age of 18. You want to avoid things like that, especially when you're talking about older teens. Policies like, if you're under the age of 18, you cannot be alone. You can't be alone roaming the property. We know that oftentimes older teens babysit their younger siblings. And so again, policies like that, saying that if you're under a certain age, you have to be supervised by an adult, those can have a disparate impact. There was a case a couple of years ago where the property management company had this type of rule where people that under the age of, I believe it was 16, couldn't use any of the amenities and couldn't be seen on the property without adult supervision. And so what happened was that two families in particular, both led by single women, their children were negatively impacted by this, and for years could not go out because their mom was working, and so they had to stay within the unit for fear of being evicted. And so in that case, there was a hefty sum that was paid out by the property management company. All right, so then the next protected class that we're going to talk about is religion. And there are some religious exemptions to the Fair Housing Act, and those are true if all of the following apply. So the dwelling has to be owned and operated by a religious organization. The dwelling must be used for something other than a commercial purpose. It must be limited to members of the same religion, and it cannot discriminate based on other protected classes such as race, color, or national origin. So I'll give you an example. If you have an organization like Catholic Charities, they may acquire a property, and they're acquiring that property not just for the purpose of housing, but they're offering some other service like case management or substance abuse treatment or something like that. So then they satisfy the first and the second. If they were to limit that to members of the same religion, so maybe all Catholic applicants or all Christian applicants, that would satisfy the third criteria, but then they couldn't discriminate based on other protected classes. So they couldn't say, well, we're only going to take all Black Christians or all Asian Christians or all Native American. Well, in that case, yeah, Native Americans, they would be protected under national origin, but they could not say we're only going to take people that come from this country who are Christian into this program. Sometimes people have questions here about sex and whether or not a religious organization that's offering case management or other types of social services can limit based on sex. And really the rule of thumb and the HUD guidance states that you can discriminate based on sex if there is a legitimate concern about privacy and safety. But there are ways to mitigate that, right? You could have single stall bathrooms or single stall showers, and that would help to mitigate the concern about privacy and safety. And when that's not possible, then yes, you could discriminate based on sex. So there just has to be a legitimate reason for doing so. Okay, so now we're going to get into disability, and we're going to spend a little bit more time on disability. When we're talking about disability, we're talking about physical or mental impairments which limit one or more major life activities. A record of having such an impairment or being regarded as having that impairment. And this also includes temporary disabilities. And so the thing that I want to call out for you here is that being regarded as having an impairment protects someone under the Fair Housing Act. So if you are a leasing agent, for example, or you're a maintenance person and you make a statement about a tenant and you say, oh man, that person seems really anxious, or, I'm not sure what's going on with them, but, I think that they might be an alcoholic. Now you've protected that person under fair housing, whether or not they actually have those ailments. You're regarding them as having those conditions protects them. And so you really want to be careful about that. Also, when we're talking about disability under the Fair Housing Act, it's slightly different from the Americans with Disabilities Act, the Washington Law Against Discrimination, and your government assistance programs. When we're talking about the types of disabilities that would be covered, the list is expansive. And so this isn't the comprehensive list, but these are some examples. So things like cerebral palsy, speech and hearing impairments, autism, cancer, PTSD, diabetes, HIV infection, emotional illness, drug addiction, and alcoholism. The thing I want to call out for you here is drug addiction. And so some landlords, some property management companies, they get concerned because they think that they have to accept people with active drug use into their properties. And that is not the case. That is not what fair housing says. It says that you cannot discriminate because someone has a drug addiction. If they're actively using, that's a different story. And that would go against your community rules and whatever other policies that you have in place. And you would handle that accordingly. But if someone is not actively using, but they have a prior history of drug addiction, that's not a reason to deny them housing or really to evict them. So that's a distinction that I want to make there. And again, with alcoholism, if you think about it, a few slides ago, I said that when we're talking about protected classes, what we're trying to do is address the behavior and not the stereotype. So you could have someone on your property, or you yourself may be an alcoholic, but so long as you are not violating the community rules, then there really is not an issue. There are people who sit in their apartment and they drink all day, and according to fair housing, that's not a cause for eviction. So just something to keep in mind. Okay, and so again, I see some folks typing in the chat. Please put your questions in there, and we've been instructed to answer those at the end. So I will certainly do that. When we're talking about disability, we also want to make sure that we're allowing people to equally enjoy their property and the unit and the amenities. And so in order to do that, fair housing law says that you have to be willing to consider reasonable accommodations and modifications. So an accommodation would be a change or exception or adjustment to a rule, policy, practice, or service. And again, you're doing that to afford that person equal opportunity to use and enjoy the dwelling, including the common areas or the amenities. And then for a reasonable modification, we're talking about a structural change. And so these could be things like shower bars or a ramp. Those, again, would afford that person full enjoyment of the premises. So we're going to get more into reasonable accommodations and modifications, but I want to start with verifying that the person has a disability. You have to do the verification before you can get into the actual accommodation or modification request. And they go hand in hand because sometimes the disability is obvious, and in that case, you really don't need to verify it. You know, if someone comes to you and they're in a wheelchair and they say, you know, it'd be really handy if I had a ramp, or, you know, if I had shower bars to help me be able to access the shower and the toilet easier. You know, that's a logical connection. There's a clear nexus between their disability and what they're requesting. And that really becomes the litmus test under fair housing law, is that there has to be that nexus. And so if that nexus is not obvious, if their disability is not obvious, or what they're requesting to help them mitigate the symptoms of that disability is not obvious, then that's when you can ask for third-party verification. And so a lot of times people automatically assume, or in their communication with the tenant, they automatically assume that by third-party qualifier, they mean a doctor's note. And that's not the case. It does not have to be a doctor's note. Third-party verification means it could be a member of the clergy, it could be a social worker. You know, a member of the family is not okay. That's not considered a neutral third party. But there are other folks who may be interacting with the client, and they have a very good understanding of that person's condition, and they can speak to why the request is needed to help them mitigate the symptoms of their disability. What I want to mention here is that sometimes people overshare in their notes, you know, whether it be a doctor's note or, like I said, a note from a clergy member or social worker. And so if you are helping to facilitate obtaining that third-party verification, you want to make very clear to the person who's getting that information that they don't need to tell the person's life story. They don't need to go into a lot of detail. They just need to certify that that person is disabled under the definition of disability, which is that, you know, they have a condition that limits one or more major life activities. And they need to be able to say what the connection is between the person's disability and their request. If you're concerned about the validity of a document, you should, best practice is really that you validate that document the same way you would validate any other documents from the tenant. And so, you know, I'm saying this because I assume that I'm speaking to a lot of housing providers, but if you are a housing consumer, you know, that's also important to note, is that you should really be thinking about what is that nexus, and you know, making sure that you provide a valid document and that your request is really something that you need. So with that being said, if you get a note from a doctor and you're feeling like, well, this doesn't really look that legitimate, you can call and you can ask the person who, you know, has signed the note to verify that they wrote the note. You can't ask them to verify anything else within the document, but you can ask, you know, are you this person who signed this note? Did you write this note? And if they say yes, you know, that stands to verify the information that's contained within the note. And again, thinking about what is your policy generally for verifying documents. You know, if the tenant were to give you a reference, would you verify that reference? You want to think about to what extent you are placing additional burdens on someone who's disabled. So really just thinking through that process. Okay, and then once you get a reasonable accommodation or modification.
Mission accomplished.
once you get a reasonable accommodation or modification request, you want to think about your response time. Typically, when clients come to us and we're helping negotiate something with their landlord or property management company, we give 10 days to respond. And so you want to try to do it as quickly as possible. And that doesn't mean that you have to automatically grant the request, but it means that you have to respond. You have to engage in a conversation with the person who's making that request. Again, you want to think about what undue burden might you be placing on the client. And so HUD guidance says that requiring a formal request process or additional forms, that places an undue burden on the client. They can make requests in writing. They can do it also verbally, and they can make that request to any agent of the housing provider. And so, previously I mentioned that maintenance staff are liable. And so if a tenant says to a maintenance person, hey, I need X, Y, and Z, it is then the responsibility of that maintenance person to make that request known to whoever needs to know it, to begin that process of opening up a dialogue, and if not meeting that immediate request, then trying to come up with alternatives. Okay, and then the last point here is that those requests can be considered at any point of the housing process. So you may have prospective tenants who come in and they're saying, I'm disabled, I have an emotional support animal. I know that's a hot topic for a lot of people. And so, they want to know what your policies are, and if they're allowed to have that animal, what the process would be. They could ask it then. You could have someone who didn't have any need for any accommodations or modifications, but then, they have an injury and they need to go in for surgery. And coming out of that surgery, they are now temporarily disabled. And so they need things to be able to, again, equally enjoy their dwelling. And so I want to make the point there, though, that even when someone is temporarily disabled, the doctor's note doesn't have to say how long they're going to be temporarily disabled. And you should not be asking how long that disability is going to last, how long that accommodation is going to be needed. However, say you've got a long-standing tenant and they ask for, an additional modification or additional accommodation or something like that. You can, within your policy, say that, you require a new verification letter every 12 months or every 24 months, unless that person is permanently disabled and that they're permanently disabled because they're receiving, some type of income that would let you know that they are permanently disabled. In that case, it might not make sense to ask them to re-verify. And maybe you're not re-verifying their disability, but you're re-verifying their need for that particular accommodation. Those things are okay. Again, the point here is you just want to be mindful of any potential undue burden that you're placing on the client. And you want to make sure that whatever you're asking them to do is not too far outside what you would ask them to do in any other case. All right, so how many modifications or accommodations can a person have? There's no limit, but each one has to be reasonable. Multiple assistance animals are allowed, but the note has to indicate the number of animals needed. There is some contention about whether or not the doctor's note or the third-party verification letter needs to state what each animal is for. But there hasn't been any clear guidance on that. So for now, we just tell people that the note has to indicate the number of animals needed. So for example, a disabled resident could have an emotional support dog, they could have an ADA service dog, they could have written reminders for when the rent is due, and they could have a ramp built for their back porch. So again, thinking about what can you do um, to help that person mitigate the symptoms of their disability and equally enjoy the property. So the question with all this is who pays, right? In federally funded housing programs, the provider pays. And so they can deny that request for modification if the tenant is not disabled, the modification is not tied to the tenant's disability, again, that nexus, and if it creates an undue financial burden. And there's no clear litmus test for what is considered an undue financial burden. That really is on a case by case basis, but that's something that you have to analyze for your own organization. But the point that I also want to make here is that we're talking about reasonableness, and so you can think about whether or not the request, either for the modification or the accommodation, if it fundamentally alters the nature of the business. So again, in addition to the undue financial burden, thinking about is the client asking for something that you simply don't provide? Maybe when it comes to the accommodation, they're asking for someone to come take out their trash every day because they're disabled and they're not able to do that. Again, that might not be an undue financial burden, but it does fundamentally alter the nature of your business because trash collection within the unit is not a service that you provide. So again, thinking about what is reasonable. Okay, now, if you are in market rate housing, the tenant has to pay for the RM. So it can be approved unless it damages the structure. You as a housing provider could request that the modification be returned to its original state. And you can require that the tenant create an escrow account to save up for restoration costs. And again, it's really about what's reasonable. I mean, we as an organization, we get requests for all types of things. People ask us to advocate on their behalf for all types of things. And when we're engaging in conversations with the landlord, we really are thinking about, okay, is this what the client needs? Is this just what they want? What is going to satisfy the need that they have, and what's going to work for the housing provider? So, for example, a lot of times people who are having mobility issues will come to us and say, well, I really want hardwood floors in my unit. I really want this carpet gone. And we'll say, okay, is it that you need hardwood floors, or would laminate work? And oftentimes the client is going, oh yeah, for sure, laminate work, that works too. I just need something that's not going to present a trip hazard for me. And so that's what we hope that housing providers and tenants will do, is engage in a conversation about what the real need is, and then think about alternatives that are going to work for all parties. Okay, now, what do we do during COVID, right? I know that a lot of housing providers are kind of backlogged in their maintenance. And so so I have two categories of questions here. So as a housing provider, some of the questions that we have gotten are, how do I prioritize maintenance requests while following the governor's guidelines? Is an RA or RM request considered an emergency? What if there's not flood or blood, and then how do I protect maintenance staff? So when it comes to RA and RM requests, they should be considered emergencies. And not to say that they should be considered emergencies over things like flood and blood, but they should be quite high on the priority list. And so, like I said, I know that a lot of housing providers are going through their backlog of maintenance requests. And so the best practice that I would offer to you is to, if you are a housing provider, is to think about going through all the requests that you've gotten, say, since March, and looking at your accessible units first and seeing, okay, has anyone who's in an accessible unit made a request for maintenance? And really starting there, because you don't want to be in a position where you've left someone who needed an accommodation or modification to kind of fend for themselves for the last several months. So to think about that, and again, to prioritize the RA and the RM requests as you move forward. If you're worried about protecting your maintenance staff, there are lots of different things that you can do. You can ask the tenant to be in another room. You can ask them to wear a face covering. You can also ask screening questions before you enter the unit. We're working with a client now, and they had expressed to the maintenance team informally that they had bronchitis, and you know, that their family members were coughing a lot and having to go to the hospital. And you know, it turns out that it was not COVID related. It was other health issues that they were experiencing. But in that instance, the housing provider and actually the outside maintenance company that was coming in to do the repair work wanted certification and wanted third-party verification. And in this case, you know, from a doctor saying that no one in that household was contagious. And it, you know, it wasn't because they were disabled. It was because they had expressed that they had recently been in the hospital and that they were having respiratory issues. And you know, we've all seen the screening questions, and so that was a red flag for the provider and cause for concern. And so the tenant was responsible for obtaining that doctor's note before maintenance would come in and do the repairs. So you know, so that's an example. There are certainly exceptions to this, but thinking about protecting your staff for sure, but doing what you can to filter out those reasonable accommodations and modifications and address them. So if you're a client, this is another set of questions that we get. You know, the property owner wants to show the unit to prospects. You know, regular maintenance needs to be done, and their health is being impacted by recent air quality issues. So, you know, you're going to have your high risk clients. And so we've had a lot of people contact us because their property owner is showing the property and they're concerned about their exposure. And so, you know, virtual tours are possible. The tenant could potentially take their own video tour of the property, and the property owner could use that to show prospects. I know a lot of people now are letting the person enter into the unit, and they stand outside and they let them you know, tour the property on their own. You know, it's reasonable to ask that people entering the unit, you know, if you're the tenant, and people want to view your property, you could ask that they wear masks and gloves. So, you know, these are just a few of the things that you can do. Again, people asking about air quality issues. A lot of people are requesting air filters now. And so again, going back to who pays, if it's subsidized housing, then the housing provider would pay. If it is, you know, market rate or unsubsidized housing, then the tenant would pay. And so, you know, just being open, again, having conversations about what are good alternatives to satisfy the need. Okay, so the presentation is not over, but this concludes the part about fair housing and reasonable accommodations under COVID. Again, if you have questions, type them in the chat. The next few minutes, I'm going to spend talking about a program that is happening in Pierce County and some of the benefits that program, and hopefully that will be a source of relief for some of you. Okay, so we want to remember the spirit of the law, basically ensuring that equal rights of every American are met, who are aspiring to rent or own a place to call home, and that no one is discriminated against in transactions because of their protected class. And so the program that I'm talking about is called Free 253. And this is a newly created program with funding from Pierce County Connected and Pierce County Department of Health and Human Services. And so there are 3 flyers here on the screen. One is for domestic violence and family safety. One is geared towards tenants, and the other is geared towards landlords. And so the purpose of this program is to provide free legal services for tenants and landlords. It's to assist tenants with navigating the Pierce County portal for rental assistance. And then one of the main portions of this program that I think will be really beneficial to a lot of folks is this mediation and facilitation piece, because we know that under the moratorium, it's been quite difficult for landlords and tenants to come together to talk about a payment plan. And we know that in order for owed money to become collectible, that payment plan needs to be in place. And so we want to prevent people from having to go to court, and we want them to come up with that payment plan as soon as possible. So what you can do is you can contact Tacoma ProBono directly, and their email is there on the screen. I'll put this in the chat as well. And basically you can contact Tacoma ProBono, and if you're having trouble reaching your tenant, you can provide their information. Tacoma ProBono will work to get in touch with them, and you all can come together and facilitate a conversation about a payment plan. And that payment plan will be on record. Also, if you're needing training on how to better talk to your clients, how to open up those lines of communication, the Center for Dialogue and Resolution can certainly help with that. And if you have fair housing questions, feel free to come to our organization as well. We are happy to work with landlords and property management companies, and with clients and tenants and social workers and everyone who has a stake in the well-being of their tenants and of their property. So, that really concludes the presentation for today. Again, my name is Adria Buchanan. I'm the Executive Director of the Fair Housing Center of Washington. Our website is fhcwashington.org. And actually, I'll put it down here. And so feel free to contact our organization as well. And so I think now we'll open it up for questions.
And Adria, I have added several questions from Lorna, Jennifer, and Melissa, as well as those you've seen from Melody, sorry. Okay, so should I read these out? Go ahead and, because the participants can't see the question. So please go ahead and read the question and then provide your response. Okay, great, thank you. Okay, so the first one asks, can you address shared housing such as Oxford and making someone leave with 24 hours notice? Okay, I'm not too sure about the details of this question, but I will say that when we're talking about shared housing, it really depends on, again, that definition of a dwelling. So in every court case, it is a case-by-case basis. And so one of the, I would say, to get a better understanding, and for everyone on the call, if you're thinking about whether or not a dwelling actually applies under and is subject to fair housing laws, you want to think about this litmus test of whether or not the person considers that place home.
and whether or not they plan to return there, and if they don't have anywhere else to go. And then if they're treating that place, as their permanent dwelling. So if they're receiving mail, if they are cooking, if they are having guests over, there are a number of factors that determine whether or not something is considered a dwelling and then would be subject to fair housing laws. It sounds like in this case, with shared housing, it would depend how long that person has been there, um, to what extent they treat that shared housing as their only residence, and asking them to leave with 24 hours notice. It also depends how many units that the person owning that property has and whether or not they would be subject to fair housing law as well. And there are some exemptions to fair housing based on the number of dwellings. But again, I'm not really sure the details here.
Adria, we just have a couple of minutes. So for those answers that don't get, questions that don't get answered, we could go ahead and have them contact you directly if you've allowed that in your profile.
Yeah, for sure. So then the last question is, can you request an accommodation in the application process, such as excluding an eviction or criminal offense because it happened when that person's mental health was decompensated? So here we're talking, about criminal guidance. And so again, our organization, we have another presentation that's on these kind of more complex issues. But basically, the guidance says that you shouldn't have any blanket criminal history or background check policies. Things should be on a case-by-case basis. And so I would say that it would, in this case, it might not be considered an accommodation because of a disability, but you could explain what that history is and ask that it be taken into consideration when reviewing the application.
Okay.
And so I think that concludes the questions that I have here in the chat.
It does. And thank you so much, Adria, for joining us. For those questions that did not get answered, we can make sure those get emailed to Adria directly, and possibly if you can also go in and do that. So just go to the information about Adria and you can contact her. Thank you so much for this information, and we look forward to getting the recording so that you can share it with more people in your organization.